staying with us this evening. Starting off the broadcast with breaking news that's coming in. Massive relief for activist Teesta Setalvad. Supreme Court grants her in connection to case filed by the Gujarat police against her for fabrication of evidence in 2002 rights. Nilashish, my colleague, joins me on the broadcast over the phone lines. Nilashish, good evening. This is clearly big relief for Teesta. Give us more details as to what the top court has said as far as the bail is concerned.
The opinion that prima facie the Gujarat High Court judgment was not correct, and also stated, in fact, that there are certain sections that have been imposed on her, but these sections, most of them are all bailable. So now the Supreme Court has definitely given bail to Teesta Setalvad, saying that we do not think custodial interrogation is necessary, and that the High Court had merely relied on a Supreme Court judgment. Now, accordingly, the Supreme Court has said that we quashed the High Court judgment which denied Teesta Setalvad regular bail. The court also went on to say that she should not make any attempts to influence the witnesses, which are, of course, regular conditions for bail. So definitely big relief coming in from Supreme Court for Teesta Setalvad, wherein the court has also stated that though the petitioner wanted to be an intervener, she was not allowed to be so. Her locus was questioned, and it is therefore submitted that without allowing her to be a party in the proceedings, remarks made in a certain paragraph of the Gujarat High Court could not have been made so. So accordingly, the Supreme Court has now quashed the order of the Gujarat High Court, which had denied regular bail to Teesta Setalvad, and has granted her bail, which comes as big relief to the activist.
Right, Nilashish, just a quick follow-up question on that. We do understand that the Supreme Court has also said that all those involved in such abusive process need to be in the dock and proceeded in accordance with the law. Is that the case?
Well, yes, the court did, in fact, pull up the Gujarat government as well in this particular case. Justice Gavai was pronouncing the order wherein he stated that the Definition of Evidence Act would have been thrown in the dustbin if the contention that was put out by the Gujarat government were to be accepted. The court also went on to say that we want to keep someone in custody till trial is over. So, of course, the court definitely taking a strong view, saying that according to us, giving false evidence is not borne out, which are certain allegations against Teesta Setalvad, and went on to say that the judgment that has been relied upon cannot be equated with evidence. So, of course, it has definitely been a case wherein the Supreme Court has, in fact, pulled up the government and stated that the entire evidence is with them, and you are saying that she has tampered with evidences, which is something that cannot be made out. So, of course, rap by the Supreme Court as far as the Gujarat government is concerned, and big relief to Teesta Setalvad.
Right, Nilashish, thank you very much for getting us those details. I understand Nutan Thakur, an advocate, is joining us on the broadcast over the phone line. Nutan, thank you very much for speaking to us on Mirror Now. This is, of course, clearly a big relief for Teesta. Can you give us your first reaction about this?
बिल्कुल फर्स्ट रिएक्शन मैम यही है कि ये बिल एक तरह से वो सुप्रीम कोर्ट ने दिया है, हाई कोर्ट से ही होना चाहिए था, और ये एक अच्छी खबर है खास करके एक्टिविस्ट के लिए जो इश्यूज को रेज करते हैं और उसके बाद कई क्रिमिनल केस फ्रेम किए जाते हैं, और उसके बाद जिस तरीके से सीतलवाड़ मामले में आया, तमाम ऐसे एक्टिविस्ट सफर कर रहे हैं। निश्चित रूप से उनके लिए जो फ्रीडम ऑफ एक्सप्रेशन के लिए फाइट करते, औरों के लिए फाइट करते, उनके लिए ये एक खुशखबरी है।
जी नूतन जी, अगर हम इसी के बारे में बात करें, जो सुप्रीम कोर्ट ने भी बोला है कि ऑल दोज इन्वॉल्व्ड इन सच अब्यूसिव प्रोसेस नीड टू बी इन द डॉक एंड प्रोसीडेड इन अकॉर्डेंस विद द लॉ, इसके बारे में आप क्या कहेंगे?
अभी तो जो भी एफआईआर लॉज स्टेट ने किया है और बिल का इशू है, और बिल किसी को भी जुडिशियल कस्टडी में रखना है या बाहर रहना है, तो ये एक मैं कहूँगी इनिशियल स्टेज है जहाँ फ्रीडम को कर्टेल किया जाता है, तो वहाँ एक रिलीफ मिली है। पूरे इश्यूज तो बाद में डिसाइड होंगे, लेकिन निश्चित रूप से इधर इस मामले में ही नहीं और भी मामले में जिस तरीके के एफआईआर दर्ज होते हैं और नेचर ऑफ एफआईआर होता है, कई मामलों में तो वो दर्ज भी नहीं होना चाहिए और उस पर पिनल एक्शन नहीं होना चाहिए। लेकिन दुर्भाग्य है कि अब तमाम ऐसे मामले आते हैं जहां एक्टिविस्ट कुछ बोलते हैं और केवल बोलने पे एफआईआर दर्ज होता है या आपने कोई कंप्लेंट करा है और उस पे एफआईआर लॉन्च हो जाता है। वहाँ इंटेंशन देखा जाना चाहिए कि आपने किया है तो वो एक लार्जर इशू को भी रेज करने को होता है, उस पर क्रिमिनल केसेस नहीं होने चाहिए, मुझे ऐसा लगता है।
Nutan, thank you very much for talking to us here on Mirana. That was Nutan Thakur, advocate, of course, giving her reaction.